It's Lisa from Been There, Got Out. And today promises to be a very active and energetic interview. There's going to be four of us if we all get on properly. So, Chris, I see you. Hey, my partner, Chris, in a separate place. And now, Sean, I see you. So Sean Valentine and David Morneau, I just invited you guys. Let's see if we end up like the Brady Bunch. Okay, 3 out of 4. Let's see if David does it. He's almost there. Yes. But David, we're looking at your window.
There we go.
There you go.
My
Well,
own
very,
technology
very
is never my friend.
All right, great.
But I'll say this, I had an easier time getting in this time, and I even have the camera more affixed than it has been in previous occasions. So it's progress. You know what? I'll take whatever little progress I can get, guys.
Okay, awesome. And I'm just waiting for your cat to photobomb.
Well, she's sleeping right now, so it may be a while.
Okay, great. All right. So I know that we always come up with different ideas, and I wasn't sure if you guys, because you guys never answered me, is this part 3 of our client as a consumer series? I don't know, but maybe not.
You know what?
Go ahead.
If I had to characterize it, I think this is a one-off.
Okay,
Because
this is a one-off.
these are questions that people will often have about the system and the just the interplay of the system and how kids, how their views get factored in. So I think this is supplemental to the work. We'll go back to the client as a consumer, but for now, I think we do this one-off.
Okay, sounds good, because then we definitely have to get Angie back in here. So
I miss Angie.
yeah, me too. Okay, so today's topic is the voice of the child in family court. And I'm sure your clients and our clients in particular are constantly terrified, worried, concerned that their child's voice is never being heard in family court. And so what can they do about it, if anything? And David, I know you in particular have an extensive background in working with children in the family court system. Can you talk about that a little bit? And also why you feel that split parenting is not a one-size-fits-all in these situations? I know that's a huge question.
Wow, that's quite loaded, but I'll do my best, and I know my colleague will jump in to add his thoughts as well.
Okay.
So for 15 years of my practice, I'm no longer on the panel, but for 15 years of my practice, I represented kids in child protection and custody and access proceedings. So my role was as their counsel. You know, like everybody else had a lawyer at the table, the kids had a lawyer as well. And I was the one that would go in and give their views and preferences to the court. So there was a process involved in that. I would interview the parents, I would review records. Most importantly, obviously, would be I would sit down with the kids and I would talk to the kids. Typically, I would have each parent, if it was possible, I would have each parent bring the kids in on individual occasions so that, you know, there was at least some observation of how the kids interacted with the parent prior to, and then I would sit down with the kids individually without the parents present and do extensive interviews. Typically, what I would do is I would have the parents leave the office as long as the children were comfortable with that, and it worked quite well, and did that for 15 years. My tenure just recently ended, and I decided not to continue, but it was probably 15 of the most gratifying years that I had, because bringing such an important voice to the table was what I was able to use with two parents who often described what they were going through in warlike analogies, to bring that voice. And oftentimes the kids were the voice of reason. And they were the ones that would be able to articulate. They'd articulate things, you know, I'd hear from the parents prior to what their thoughts about what the children would say, but then I would sit down with the kids, and oftentimes it was a different story from what the parents had articulated. It's unfortunately we have a system, the legal system being set up as adversarial, um, can cause the children to be weaponized as well. And we're hearing that word a lot more. And although I don't like to use war type analogies or battle type analogies when it comes to kids, it's appropriate. Kids do become weaponized in this process. So just in short, I think the question is, our law oftentimes, or it starts from a presumption of, it used to be a little more entrenched, but it starts from a presumption of maximum amount of time that a child spends with each parent. And one of the realities that I came to is, often you have multiple children, and what was good for one wasn't necessarily the same as another and another. And the reality is, I remember one case I had where there were three different children who had three different types of relationships with the parents and spent different amounts of time. And for the parents that may be listening in, taking that approach sometimes is helpful too, that it's not one size fits all. Who is this child as an individual? And I think we're going to get into that a lot more as we progress into this conversation, because that is the key question: is how do we ascertain who that individual is, and what that individual's needs are, and what that individual's views are?
Well, so
Yeah.
when it comes to that, what has worked for you in terms of making sure that their voices are heard?
Was that for me, Chris?
I
That's
don't
for
know,
either
David. I
you.
don't know if Sean will get to talk. That was for you.
I'm
I'm
reluctant
to
to press
Dave
play.
first. Don't you worry.
I should have apologized to Sean in advance. But
Oh, I knew what I
but
was getting into. Don't you worry.
yeah, it's Chris, it's kind of a difficult question to answer, because like anything else in a systemic way, different individuals approach the system differently. But in theory, children's voices would come to court, at least in our jurisdiction, in Ontario. Um, there is, in most provinces, if not all provinces, have an office where it's called the Office of the Children's Lawyer in Ontario, where the court can make an appointment or request involvement of the Office of the Children's Lawyer to provide the views and preferences of the child in terms of, insofar as they can be articulated, because that's what the law says. The law says, in determining what's in the best interest of the child, you have to take into account their views and preferences if they can be ascertained. So the Office of the Children's Lawyer in Ontario is set up, and it's two prongs. One is, like I did, counsel. So as counsel, I'm an active part of the case, and I'm presenting to the court. The second way is with a clinical investigator that comes in, and the clinical investigator will do um, a fulsome reports. Usually they're about 30 pages long, where they sit down with both parents, and that results in making recommendations on the basis of what the children's best, or what the children's views and preferences are. And there are other ways too. I mean, in Ontario, you can have a private assessment done. I've often heard, and I see people. I'm communicating with a lot of people, particularly since the last time we met, and things in my practice have really been hitting on all cylinders, and people reaching out with concerns about uh, children's voices being suppressed, or children's voices not necessarily being properly represented. And those are natural questions that often come up. And unfortunately, when you have an adversarial setting, those things are bound to happen, because the adversarial setting really is set up as a zero sum game, right? You guys have been through that. You've both seen that in the system.
Yeah, quickly, what's the difference between an attorney for the child and someone like you? Because where we are, I always think of it like a guardian ad litem or a custody evaluator, and we just have one person with that role. But it sounds like there's two. There could be two. What's the difference?
No, there would just be one,
Oh, there would be.
and it was a panel of specially trained lawyers. You have to go through a formal process where the government, the Ontario government, would put you on a panel. So that's not to say that people don't sometimes reach out for private representation, but the government not only provides that representation, but they pay for that representation as well. So parents don't have to pay for that.
That's amazing because here it's usually $10,000 to $23,000 that we've heard of, right, Chris?
Absolutely. Mine was at the high end.
Yeah.
And did very little to influence the case, which I know is unusual. Usually these people have a strong voice. Judges listen to them.
Yeah.
Yeah, the direction that I chose to take more often was to, I mean, again, sadly, sometimes you get some that are better than others. That's one way to look at it. I would often use their voice to help navigate and sit the parents down. More often than not, the cases that I was involved with were able to settle before they ever went to a trial stage,
Wow.
because with the influence of not only what the child says, but when you start getting into things like settlement conferences and then you have a judge as an audience, to be a strong advocate is very, very important, and making sure that when I was stepping into that courtroom, this young person who in all likelihood very often would tell me in very definitive terms, this is what I want, or they would talk about the acrimony between the parents and they want that to stop. They would give me pearls of wisdom. I mean, this is the thing. You know what? We have a United Nations convention that I think both of our countries are signatories to. I mean, we're both represented in the United Nations. And there's a convention called the Convention on Child's Rights, the CRC, Rights of the Children, and really, I think even lawyers need to go back to that as a foundational document, of a foundational start. What are we there for? And what does it mean to bring their voice to the table? Because I've seen it where it becomes articulated more from the perspective of the professional. This is what I think should happen, as opposed to at the level that we're supposed to be bringing it in as, and that's at the child's level, making sure that it's the child's voice. Now, when I would sit down with, kids may tell me, I'd like a unicorn and a lifetime supply of chocolate, or I'd like chocolate cake for breakfast every day, right? And being able to suss that out. And I love those conversations with kids, right? They're genuinely child-focused conversations. That's where the kids are. And yet they're being brought into oftentimes very adult situations where they're feeling that pressure. And, I took it, I mean, it was very important to me, but it was also an honor for me to hold space for these kids, to be able to listen to what they had to say as they're navigating this transition. The reason why I use the term families in transition as opposed to divorcing or separating parents is because the whole family is impacted by it. And that includes the kids. So they're going through this transition from people being together to people no longer being together. And what does their world look like? And they're full of the same apprehensions that often parents are going through. What does my world look like tomorrow? How am I possibly going to live in two homes? Why can't they stop arguing, or why can't one parent, or both parents stop saying negative things about the other? Because oftentimes it does tend to come from both parents. Sometimes it came from one parent, and just kids recognizing that and carrying that weight on their shoulders, making sure that they have a voice. It was so important to me to step in. And when I stepped in, my representation of them was as if I was representing you, Lisa, or representing you, Chris, when I walked into a courtroom.
Wow. Yeah, that's great. All right. So now my next question is based kind of going right off what you're saying, David, is the kids become part of it even when we know that they kind of shouldn't be. Sean, let me give you a turn to start with at least.
Our
Why is
guest
it,
today.
a lot of victims of coercive control, we can't help showing what's going on to our kids. Why isn't it good for kids to be part of that, Sean, based on what you've seen in your career as well? And then David, you could talk after.
Sorry to clarify, part of what exactly? I'm sorry.
So part of like what's happening during family court. So it's always like high emotions.
Gotcha.
I know a lot of the written things say don't involve the kids. You're not allowed to talk to the kids about what's happening, but kids see it and they sense it. But why
Well, it
do
is-
these things say don't involve the kids, and why can it be so harmful for them?
Right, and especially early on, right, before people figure out that they're supposed to behave a certain way, like right at the beginning, before we know what we're doing.
Gotcha. Yeah, it's so imperative to try to keep the kids out of the mudslinging and out of the confrontation that happens. And really, these kids of all ages are so impressionable, right? They really develop a lot of mannerisms and behaviors that are associated with their institutions and with the people that they're around with. And so we always say that the primary goal is to try to be that if you have some issues between each other, don't bring it into the fold. Don't air your dirty laundry out with your kids. It's such an important thing that they maintain a neutral situation in this whole process, because just like Dave was saying, we still want them to maximize the parenting and the time that they have with their families, but we also have to be careful that we're not influencing them in one way or the other. Now, that obviously goes if there are safety concerns, if there are issues that come up, that's a different story. Those are things that actually do have to be raised and they have to be discussed, because those are factors that we talk about when we decide decision making or parenting time or custody issues or things like that too. And so, but there are ways to handle that, right? There's not a way of having to yell back and forth and get lawyers involved. And that's actually where that OCL, or what Dave has been doing for the last 15 years, is very helpful. That if the judge does see that there is conflict or there is problems that are between the two parties or two spouses, we can bring in someone who's going to be a bit more neutral and who's going to be able to pull out that information and provide it in a much more coherent way that isn't going to be about yelling back and forth or blaming each other about it. And really, that's where we get those real neutral pieces of information that we can actually take to a judge, and we can say, look, this is actually what's been happening, and there is no coercion or there is no control in terms of the information that is going to my kid. And then it becomes tangible evidence that is really very very influential to a judge when they hear it, because then they can really say, like, this didn't come from mom or this didn't come from dad. These are truly the views and preferences of that child in the circumstances that they're in.
Yeah. I was going to say, is there ever times when it's almost dangerous for the kids to get involved?
Yeah, I would say 9 times out of 10, it's dangerous to get them involved. But at the end of the day, they are still affected by the situation that's happening in their separation. And we have to make sure that they are protected. Kids still have charter rights in Canada. They still have human rights all over the world. And we have to make sure that they're protected in these processes. And they are generally the most marginalized and most, the people that we have to protect the most out of this whole process, because they're the ones that are going to be going through and don't really have a say in how their parents are behaving or how a decision is going to be made about their living arrangements afterwards. So no matter what, as much as we want to shelter and protect them, we have to make sure that they're protected properly in this process.
Yeah.
And to that point, guys, I mean, this is where some of the changes that have happened in the Canadian legislation, prior to, within the last year and a half, when changes were made, and there was no definition of family violence. So there was some reference to domestic violence in general, but the changes to the legislation open things up. More fulsome definition of family violence. The fact that even in the face of determining what's in the best interest of the child, one of the factors will be um, will be that child's views and preferences, but you also have to factor in the impact of family violence. And this is where we start getting into this area, for me, that has become so much more critical, especially since the last time I've talked to you guys. One of the things that I had said when I got interviewed when the legislation changed, and when there was discussion about, great, you know what, we have this definition of family violence. Well, we have professionals within the systems that don't understand what it means. They don't have the proper education, judges in particular. What is the impact of family violence on parents, right? And let's be even more specific. Uh, what is the impact on mothers? Because more often than not, statistically, we know that intimate partner violence, family violence, impacts women. Um, but what is that impact? And taking that into account. So it's great. We have a definition. We recognize that this needs to be acknowledged, this needs to be analyzed, and it needs to be taken into account. But if you don't have the proper education, one of the things that I learned in taking, and Sean's taken the same training that I have for intimate partner violence and coercive control, is that holy crap, how much have I missed over the years? As a professional, wow, I didn't think to ask that question before, because the person came in and presented uh, sophisticated. They weren't necessarily they didn't show any signs of physical abuse, because that was often the misconception, is that abuse is only physical abuse. And so we're becoming more enlightened and more evolved when it comes to that. However, we still have a system that is resisting. I shouldn't say that. Maybe not resisting, but there shouldn't be a fight for the professionals within that system to have the proper education on the people that they're representing, the people that they're assisting along the way. And that's where, so one of the Keira's law, and I know that there was going to be some mention of that at some point, so I'll just jump the queue and say Keira's law is, there's Jennifer Kagan. Dr. Kagan is a woman who in Ontario um, had some serious concerns about the abuse that she had suffered, and in the pattern of behavior that she was seeing in the father. And so she had brought numerous motions to court to have the father's access restricted. Family and Children's Services finally did an investigation, but what ended up happening was the investigation happened on the Friday, and they decided to defer it until the Monday to pick up the investigation, recognizing that there were some serious concerns. And I think an interview, a tape that's come out, the worker even said that she believed that this person was capable of homicide. Well, sure enough, sadly, the 4-year-old daughter Keira was killed over the weekend and found at the bottom of a cliff. It's believed that it was a murder suicide. So Dr. Kagan took this grief, and her husband Philip Viator have taken this grief, and they've launched this initiative, this movement, this reform to change the law and make sure that judges get educated. I'll go one step further, as I have right from the start. All professionals working within the family law systems, be it court or be it outside of court, need to have this training, need to be able to recognize, need to be able to assist families in the best ways that they can. It was so eye-opening when I got educated, and I'm sure, not to speak for Sean, but Sean and I have had this discussion. Wow, how much did we miss over the years? Simply by not recognizing certain things, whether somebody got quiet and we didn't pick up on the body language, or sometimes somebody became more aggressive, and sometimes they were painted as difficult clients, and the reality was we weren't asking the right questions. We weren't understanding where they were coming from and what they had been through to be able to best help them.
Yeah.
Right. And talking about like educator awareness in the system, there's so much noise, like here in the US for sure, about reforming family court. And a lot of people believe that, the way to do it is to educate judges, and people are sending like anonymous letters to judges and, try to tell them all about these issues, and lawyers as well, because the lawyers today are the judges tomorrow, right? But you guys see it a little bit differently, right? As far as how to reform the system. You want to talk about that a bit?
Yeah, I know from my perspective, within the system, one of the things that I recognized, for example, when I took the training was, okay, I'm good at practicing law. I'm good at disseminating that information, giving opinion and advice when I have the information. But you know what? There are other professionals that know far better than I do. So augmenting our systems, and I use the word systems because systems can encompass court. It also encompasses anything outside of court. How do we augment our systems to make them better, to recognize? I mean, criminal courts in Ontario, many criminal courts have things like mental health court, substance abuse court. Why not augment our court system with professionals that have these areas of expertise? This is where I'm talking from my perspective, having practiced law for as long as I have. But one of the things that I've recognized is listening to people who have gone through the experience, because I've only gone through the experience through one lens as a lawyer. I haven't gone through the experience as a victim. I haven't gone through the experience as a separating spouse. I haven't gone through the experience. So why aren't we listening to the people that are most impacted by it to get their perspective on things? So what I'm offering is my view, but that view is very open for communication by other people who have been impacted by it.
Yeah, I think I remember you had said something about bringing in, like you say, not just victims, but specialists who really understand these issues like domestic abuse.
Well, why would you would you go to the mechanic if you needed dental work? And yet, one of the things that troubles me is that professionally, oftentimes there's ego and hubris that seem to get in the way of progress. If we're recognizing, I've said from day one of my practice, well, you know what? I recognize, yeah, as I was taking people into court, as I was filling out their court documents, well, it's not a really good system, but it's the best that we have, and this is what we go to. And yet, where is the change? I mean, so if the change isn't coming from within, if there is going to be so much pushback and resistance to change, then you know what? Maybe other systems need to be created. Maybe the people need to start speaking and saying, you know what, this is what we want. Because I'll tell you right now, Sean and I in our firm are listening to people as opposed to trying to fit within a system that necessarily says that you have to do things this way, and this way. And I'm not saying you scrap the whole system. I'm saying that let's evolve it. But if there's resistance to evolution, then what are you left with? Well, then you guys are going to be the ones that push back. I always thought that the change would happen from the professionals within the system. I always thought that, you know what, the judges and the lawyers, having seen this, are able to change it. And you know what? I was bitterly disappointed when I saw resistance to change. And then I started recognizing that, you know what? The people that are impacted, they're getting smarter. And you know what? They're becoming more savvy. And we're seeing more success with self-represented litigants or pro se litigants. I love that. I love that. I know Sean talked to you guys.
So David, this is part 3 of the client as a consumer.
Well, just a few minutes, but yeah. And I mean, Sean, that's your thing too. And I know we wanted to talk about pro se people. I think here it's like 1 in 4, not just in family court, but like David said, we're becoming smarter. I mean, I'm pro se and moving along. It just takes a long time, but definitely been successful.
Yeah.
So any comments on that, Sean?
Well, the one thing I would also like to piggyback on what Dave was saying before too is that the system needs to change, but you also have to remember that, especially in some in Ontario and maybe other jurisdictions as well, the bench in terms of the local judges, they might not be family lawyers before they got appointed. They could be commercial lawyers, they could be corporate lawyers, they could be different things that don't really have a background in those specific, that important area of family law, that they can recognize some of the domestic violence or the coercive control issues. There are courts in Ontario that are specialized and are specific family based jurisdictions, but there are others that are in smaller jurisdictions that are having, you know, different judges from different backgrounds judging and making decisions on these decisions that affect families. And sometimes, again, they might not have that training. And so that's why this push to get this education is super important from the family perspective, the family law context, because they don't necessarily have the training in terms of the understanding of the inner workings of the family dynamic that really do lead to the decisions that need to be made for these families. When it comes to self-represented parties, the same thing comes in. You're right that all these self-represented pro se litigants, they are getting better, they are getting smarter, they're getting empowered because they have to be. They have to be that way for advocating on themselves. It's the same thing as if you go to, you know, a hospital. You have to advocate on yourself for the right type of care that you're going to get. The systems are just bogged down. There's just so many people that need to go through it, and there's only so many resources that a judge or a court necessarily has. And so even if you're retaining a lawyer on a full scope basis, the client needs to be, and I guess we're talking about the client as a consumer now, ironically, but they have to be informed and they have to be a part of it and empowered during the process, because if you don't, then you're just going to sit in the back and you're not going to feel like you actually have the right education or that the right decisions are being made for your family or for you personally.
Yeah. So speaking of self-represented, I figured let's just jump in now with the big landmark COVID vaccination case with the child. Who wants to talk about that?
Yeah, I'll start.
You know what, Sean? Yeah.
So what was really interesting? So this case came out in about February, and the idea is that it's surrounded through a vaccination case, and the theme is about one parent not wanting to get a child vaccinated and another parent wanting to get the child vaccinated, or two children actually. And what the two important things that actually come out of that case, and it's really not even about whether they should get vaccinated or not. It's the one thing was that the views of the children really were important in this case, and the views were actually to say, I don't want to get vaccinated because of X, Y, and Z. And the judge actually weighed that evidence and made a decision on that it was credible, that it wasn't coerced, that it wasn't being, vague and stuff like that. And so that was a really important thing. But what was actually so important was that the mother was actually a self-represented litigant in this whole process. She was successful. She actually did provide significantly better evidence, better oral arguments, better submissions than the father, who was actually fully retaining a lawyer on his behalf. And what was so important about this, and the judge's case, the Justice Pazaratz, who's very well known in Ontario for kind of just saying it like it is. Like that's kind of how he broadcasts his opinions. But he just said that when did we turn as a society to just blaming people back and forth? Why are we casting doubt on a person's beliefs or thoughts and just saying it's a lunacy, it's a lunatic idea, they're out to get, conspiracies and this and that? And what Justice Pazaratz really said was, Mom provided evidence, Dad didn't. Dad was painting Mom as a crackpot or someone who had different ideas, and Mom actually came in and said, this is the information I'm relying upon, and did it in a very incredible way. The most important part about it was that the judge basically said that, if I took her submissions and father's submissions about vaccinations and figured out, okay, how did Mom explain the vaccinations and how did Dad explain the vaccinations, Mom would win on that too, because the way she presented her argument was so succinct and so credible, and Dad didn't look great. So what even though the theme of the case was really about the vaccinations and whether kids should have decision making, or what parents should have decision making about it, it really, the undertones were about how great a self-represented party can do in court, and some really good pointers on how they should present their evidence and not worry about just, discrediting and saying that the other person is a horrendous human being. We're just talking about actual evidence and actual facts when they're bringing a decision to a judge.
That is so
Well,
awesome to hear, especially because it's like the bullying tactics didn't work.
Exactly.
So she kept her focus. She stuck with the evidence. She stayed calm.
Yep.
And she won. Even in all of these other cases regarding COVID vaccinations where everybody's lost because the CDC, and so it wasn't even about CDC, it was about the character of the parent.
Pretty much.
Right.
Well, and just jumping off of what Sean said, there were a couple of things. One was,
Uh-oh.
Oh, he froze.
Oh no! I was like, is that me or is that David's froze?
No, we're all.
All right, David, you're
What was he gonna say?
Let's see. Let's see. I hope we don't lose him.
What I can say while we're waiting for him, though, is that
Yeah.
people are always so concerned about the he said, she said battle. They're always like, well, he said this. I have to go back and comment on every item that they said because it's factually incorrect, or it's terrible, that it's, or it's just a straight out lie. And really, at the end of the day, most judges see through that. They really see that the facts and the evidence you present in a calm demeanor and a calm manner is so much better than addressing every targeted point at your character or the person, the parent that you are, things like that. And so that's really important. And I think now Dave is back and we're on suspense of what he was going to say.
well, so the cases up to that point, Sean, were coming down very clearly in favor of vaccination.
Mm-hmm.
So that's one critical point. Second thing is he made sure he actually re-released the decision and made sure that he said, even though it's none of anybody's business, I'm telling you guys that I'm vaccinated and I believe in the vaccination. So that was the second thing. But he quotes at the very beginning of the case, he goes through a series of questions about how divisive things have become, how polarized things have become. And he says, and is misinformation even a real word? Or has it become a crass, self-serving tool to preempt scrutiny and discredit your opponent, to delegitimize questions and strategically avoid giving answers? Blanket denials are almost never acceptable in our adversarial system. Each party has to always have the onus to prove their case, and yet misinformation has crept into the lexicon. And he says, a childish but sinister way of saying, you're so wrong, I don't even have to explain why you're so wrong. And I thought that was because he picked up. Now, sadly, I just found out today, Sean, Justice Pazaratz is going supernumerary. So he's in the process of retirement. He'll still be around. But I would encourage people to look up cases where Justice Pazaratz has rendered a decision, because he comes out very clearly and he talks about behaviors, right? Behaviors. And in this case, the father was represented by a lawyer and yet just completely launched into ad hominem attacks, which is oftentimes what we see in the system. And good on him for being the judge to say, no, I don't care that this is how it's been decided every way. This is this individual case in front of me. These are these two individual children who have views and preferences, and I'm going to base it on this individual case. And you know what, we're finding, so two pretty significant cases in Ontario.
David, before you say it, can you just say what the case is again? Oh, somebody just actually, Sean just wrote it in.
I put it in the chat.
Yeah, perfect.
Yeah, a couple of people were just saying, can you remind us of exactly what case this is, because they want to go look it up. So it's right in the comments. Can you just say it out loud, because when we post a recording, it won't show the comments. Sean, can you say it?
So
yeah, it's JN versus CG, and it's a Ontario decision, and the citation is 2022 ONSC 1198. If you just type in Justice Pazaratz vaccine on Google, you'll get a laundry list of articles that are written about it.
Okay, great. Thanks.
and then
Okay, sorry.
and then type
Sorry, David.
and then type in Justice then type in Justice Pazaratz and you'll get a whole litany of cases where he just seems to be the one that kind of cuts through the crap and says, and he recognizes things. So we've had two pretty significant cases in Ontario. The tort of family violence that Sean talked about in the previous Instagram live, that was a self-represented litigant too, where the court made a finding of a tort of family violence and awarded compensatory and punitive damages in that case. And it's precedent setting. Not surprisingly, it's now under appeal. And it's Pazaratz, Pazaratz. I'm just reading the question that came up.
Yeah. And Z means
What?
Z for those of you Americans. So Pazaratz, right?
That's right.
Okay.
That's right. Or Z.
Yeah, or Z. Okay, keep going. So yeah, so she won, what was it, $150,000? Victim of coercive control, spouse for 15 years or something. Yeah, so Sean and I we did a live on that topic. All right, sorry, David, keep going.
No. It's just, so I know that your organization is assisting a lot of people who are finding themselves self-represented, and there's so much of an interplay here. You don't necessarily need a lawyer all the way through, but you know what? You may need to talk to a lawyer along the way. Having people around to coach. I've said this before. I think I've said this in every Instagram live that we've done, the importance of the work that you do. Somebody had previously said, I want the judge to see who that person is. And that's a very important point that person made, in that the challenge always is, how do you do so in a way that doesn't look like, it's like telling your friends, you need to know this about this person, and I really need you to know this, and they're not seeing it, and so they paint you. And that's one of the things that we need to navigate through better. This is where better education, I think, will help, because being able to ask questions, and it's not just questions of the victim or survivor, it's questions of both people to get to know who these individuals are. Better questions need to be asked.
Right, and we always talk about with our clients in our community, it's not just about the facts, it's your credibility and your ability to persuade someone. Like, no one's going to listen to certain people who present a certain way, but that's a whole other topic. Okay, let's get back to also the stuff with the kids. So I know that Chris and I had interviewed someone actually off camera, because he's like a New York City detective, child protective services investigator, and he can't go public. But he said that we had asked, why don't the courts seem to listen to young kids' testimony? And he said it's because they're not swearable. Like, they're too young, their comments aren't considered accurate, and so therefore they're not believable. So in either of your experiences, how can little kids be assessed for credibility? Like, how do you know, what's a way to be persuasive?
Well, I mean, I have to say that my experience, and again, I'm in Ontario, my experience has been quite different. I think there is a lot of investment by the judiciary in listening to what children have to say. Typically, it doesn't result in the judge talking to children directly, although that may occur in certain circumstances. I've seen that. But in terms of the voice, I mean, one of the things what I was tasked with as a children's lawyer is to be able to say, what is the strength of what they're saying? What is the independence? Strength, independence, and consistency were three of the factors that I had to look at. So you don't get that in one interview. You get that by spending time with children. And you know what? I had children, I was appointed for children as young as 3 and 4 in cases. And you know what? I found that if I got down at their level and simply sat down, they don't want to talk to a lawyer. First of all, I would never go in there dressed in a suit. Secondly, they don't know who you are. So, like any other relationship, if you don't establish any kind of trust and you simply have a checklist of questions, well, you're not going to get answers. But if you sit down like any child and or most children, get to their level. And so sometimes I had appointments where it was an hour of coloring and watching Pokemon videos, right? But you know what? That one meeting with the child, the next time I met with them, they know me. They feel like they know me a bit better. And they start, kids are amazing in that the most credible people are children. In my experience, children are the most credible because they haven't developed these tactics of, saying things for a certain purpose to gain a certain advantage. Now, it's not to say that children don't lie, don't get me wrong, but it is to say that, you know what, kids tend to be brutally honest. And I would get information from them about some of the things that they had observed, for example. You know, mommy and daddy got into this fight, and it comes off as, very matter of fact, because a lot of times what we have to recognize is what may not be normal for us has become normal in their world. The tensity, the fighting, even abuse. Kids haven't developed that sense of, okay, that sense of comparison. Um, so there are ways to sit down, and oftentimes kids will be the ones that are the most brutally honest. Concerns about them being manipulated typically come out. I mean, I think we talked about the one case that I had, and it was a teenager, and he went from his initial statements, and it wasn't even to me. His initial statements had been, I'd like to be with my dad. There's this stuff going on in mom's home. I'd like to be living with my dad. And based on my analysis of things in my first interview, I think he was sincere. And 2 meetings later, his view was, I don't even recognize that person as my dad. I called him by his first name, which everything that I had seen up to that point and getting to know this young person, and you could see it. You could see it in his body language. There was an insistence on people coming into the room on the one parent side, people coming into the room with him. And you could just see it. And it was the only circumstance, or one of only two circumstances in my career, where I actually asked to be removed from the record as his counsel because I felt like I was serving no useful purpose. If there was no way, and said to the judge, Your Honor, I have to assess the strength of what he's saying, the independence of what he's saying, and the consistency, and gave my commentary on just in terms of what I had seen in terms of a progression. So manipulation can happen, but the reality is if you take the time to get to know kids, they're going to tell you ultimately what's truly on their mind, and asking questions, when they present, kids would come into my office. I need to tell you something right away. Mummy did this. Okay, so let's pause for a second. We'll get back to that in a second, but let's just have a conversation. So let's talk about this. And then a lot of times, they've forgotten about what was so urgent for them. You have one parent bringing them in, and they're immediately making an allegation against the other parent, right? So it's about having that skill set, and I don't think that I have a special skill set other than I listen and I ask questions. And that's a skill set that we can all have if we're patient and we don't have in our minds, we think we know what the answer already is. If we come to it from a mindset of curiosity, I'd like to know. That's where we're going to get with it. And kids, like I said, in my experience, kids were brutally honest. So in terms of the credibility issue, they're not swearable. Ontario's found a way, and Canada's found a way to get the children's voice in there. We have a United Nations Convention on the Rights of Children, and I would take people back to that as the foundation. Either we're taking it seriously or we're not, right? And just because a kid can't be sworn, well, that doesn't necessarily mean anything if a professional can take the time to get to know the child and speak to them at their level. Kids as young as 3 and 4 can tell you exactly what's going through their mind.
That's why I like to say, you Canadians, we can learn a lot from you with this stuff. I think you're ahead of us. Okay, let's talk about preconceived bias. What is that?
Well, I think that an important thing to remember, and I think we talked about this before, especially when it comes to self-represented litigants, or even in high conflict situations, you defer to someone who's represented by a lawyer. A judge generally does. You defer and you think that this self-represented litigant or party is not necessarily going to know the processes or know what needs to be done or the legal routes and stuff like that. And so there's certainly, on my perspective, when I coach clients, there is this preconceived bias about self-represented litigants not entirely knowing what they're doing during the process. There's also sometimes, and people, when they come into our office a lot, and I'm sure Dave can speak about this too, there's an automatic assumption that one party is automatically going to get custody or decision making of the child no matter what. And we always say, let's pump the brakes. Every single file, every single case is a case-by-case scenario. We have to look at the facts. You can't have this preconceived notion that this is the way something is going to happen, because that's not necessarily what is in the best interest of these kids. And so you have to make sure you go into a situation like this knowing that just because you think one way doesn't necessarily mean it's going to happen. And also, when you're going into court, you have to recognize too that what we always talk about, if you're empowered and you know what's going on, you can represent yourself better than some lawyers can represent the other side. So you really just have to stay focused and understand that. And that's what I see with preconceived bias. But Dave can probably shed on a bit more light too.
You know what, Sean? I think this is why we're practicing together, right? I don't have anything to add. In terms of Sean's thoughts, I had more recently very challenging lawyer, I'll say, who devolved themselves into attacking this individual who was self-represented for a while in every letter. My view as a lawyer is, I don't know what the hell went on. I wasn't there. So why would I write a letter from the first person attacking you because Lisa told me something?
This happens all the time. All our clients constantly are bullied directly by opposing counsel who this is the terror that they come to us with, of the lawyer is saying this about me.
Yeah. At 10 p.m. at night on a Friday too, by the way, right?
Yeah. And I think Sean and I and our partner Anna Marie have all run into this more recently because we talk about it, and it's that bullying mentality. And this lawyer said to me, I didn't accept the invitation into this drama triangle with them where she put herself as a hero and her client is the victim and my client's the bad guy. And I simply just paused and I said, sounds like the communications have been pretty challenging. And it was like the air came out of the balloon. And this lawyer said, and I'm so glad that you're involved. And I said, well, maybe it would be helpful if our skill set is this. We can help them resolve the legal issues, but maybe if we brought somebody else in to help with the communication. Unfortunately, my experience with those lawyers is as quickly as they take that one step forward, they'll take 10 steps back. So I got a letter this week, which was, brutally attacking my client again. And, it's that preconceived notion. All right, Chris, are you back?
Yeah, Chris, you were spinning. Okay. All right.
Okay, I'm glad it wasn't me for once.
Sorry about
All
that.
right.
Chris just assumed it was me.
No. Okay, so you got this letter attacking your client again.
Right. And the reality is now, when I sat down with my client, he's like, I only stuck to the facts. Okay. And I sat down, I said, okay, well, you said this in the letter. Well, yeah, I was kind of caught up in the emotion. I said, and there's probably more of that, isn't there? And just dialing it back, and Sean does this all the time when he's talking to people as well, when he's coaching through Family Law Coach. We all do it. How we communicate matters. It really does, because it leaves people with an impression. And think about other circumstances when you're spinning things out. Have I seen somebody else act like this or portray things this way? And how did I react? Put yourself in those shoes uh, to make that point, right? To make sure that you're addressing this. And Angie just popped in and said, you know, there are lawyers that don't ever question, don't question what I say or what I do, but you get to a point where you're like, is this an episode of the Twilight Zone? Like, am I completely missing something? And it's something that, you know what, again, the consumers will push the lawyers to be better at what they do.
Right.
Yeah.
And David, that's something we see all the time where, they're usually the attorneys for our clients' exit, former partners, where they're talking, that other parent is toxic, and they gravitate toward these bully attorneys who will just like enable them and parrot everything they say. So that's like a constant in our lives with our clients. But another thing we see all the time is like kids who, in these situations, they feel concerned that there'll be repercussions from the toxic
Yep.
parent if they speak up. So I'm sure you've seen that before. Do you have a story about that?
Yeah, well, I mean, I think the story I told earlier, it may be illustrative of what that young person was going through, that they were worried about what the repercussions would be. So the straightest line, the simplest answer was simply to proceed ahead with what that parent said. And so I think that example I gave earlier serves a couple of purposes. It was because I mean, there's no doubt in my mind that there was a very significant element of manipulation of the child. And this kid just out of out of a thought of self-preservation said, you know what, I'm going to take the straightest path.
Right. Or
Yeah.
they feel so safe with the healthy parent that they know they're going to be loved no matter what on that side. So they'll actually side with the toxic parent because that's
Some some Sometimes that happens, and this is where you need professionals within the systems that are educated to recognize that and say, although, I was in that case, I was inviting the judge to recognize that although this was a 14-year-old kid, and that's the other thing, the older these kids get, the idea is, well, they get to make these decisions. But this was the one case where I truly believe that this young person needed a judge to make a decision that was different from their views and preferences, which
Mhm.
is still the prerogative of the court. The court maintains that prerogative. They can say, okay, I've heard what you had to say. And instead, the judge's comment, and quite frankly, it was lazy, was, Mr. Morneau, how do you expect me to make a child do that which they don't want to do? What do I say to that? Thank you,
Mm.
Your Honor. And I showed up in court the next time in front of the same judge with a motion to remove myself from the record because I'm not serving any useful purpose. If you're not going to do your job, how do you expect me to do mine? Right?
Yeah. I think the one
Yeah.
thing that's also important too, though, and you guys touched upon this too, is getting getting the right social networks and the right institutions involved for those kids. You can only do so much on your side, but you need to try your hardest to ensure that they're insulated with positive reinforcement and counseling, even if they need it, or different types of therapy. Because if the one parent is not going to necessarily do that, ultimately, you know that you got to set your child up for success, and making sure that they're surrounded with the right type of people is really important.
I also wanted to touch on, guys, because we haven't really gone down the path, but it's along the lines. Here we go.
Ah, there's the cat.
There's the bomb. Um, Along the lines of concerns about manipulation. So one of the questions that's really emerged more recently is the interplay of parental alienation and, quite frankly, is this even really a diagnosable thing, or have people made a cottage industry out of diagnosing parental alienation? So there's a lot of interplay because I know that you guys are representing a lot of people who have suffered through domestic violence and intimate partner violence and control. There's a line of research along the lines of why it's inappropriate for the court to even analyze parental alienation in cases where there are elements of domestic violence. So I wanted to make sure that I just gave a plug for, because there's research on this website in case anybody is looking for it. It's
Definitely.
the Center for Research and Education of Violence Against Women and Children. It's out of the University of Western Ontario. Dr. Peter Jaffe, who is one of the foremost experts in the world on the family law systems and domestic violence. He's very much a part of this research. And just in case people are looking for some resources, there are other resources on that website too. And I would highly commend people to, especially if you're representing yourself, do some research. There's research out there.
Great. Okay.
Credible
Dr.
research.
Peter Jaffe is Jaffe, right?
Yeah, that's correct. Yep.
Okay. Great.
And Dr. Jaffe, so when I had talked about Keira's Law more recently, I apologize, folks, that she's just needy right now.
No, we love the cat.
I feel like Dr. Evil in Austin Powers right now. Dr. Jaffe was part, so there was W5 is a news journalism program on CTV in Canada, and a couple of Saturdays ago, so it's just letter W, number 5, did a segment on parents who kill, and Peter Jaffe talked about the differences between men and women in terms of circumstances like that, and how statistically, oftentimes, if this happens at the hands of a mother, and there was one mother in there who had killed their child, those are the extreme cases, but those are things that my point is there's a lot of research out there to help. So don't think you have to navigate it on your own. Don't think that you're on your own to have to convince. There's research out there that can help and talks about the interplay. So for those that aren't educated, the judges that may not be educated on these types of circumstances, do the research. Thank you for finally lying down. Jeez.
All right, guys. Well, this has been a pleasure as always, and super helpful and informative. I can't wait to start slicing it. Well, I'm going to post the recording, and then I'm going to start slicing up little clips for TikTok as well. And then we will have to plan our next live together, part 3-ish, 3.5 of the client is consumer.
3A.
But
3B. We'll call it 3B.
3B, that's right.
This was 3A. We'll do 3B.
All right, fair enough.
Yeah. But thank you so much for all your wisdom, and also hope about how to get that child's voice heard, and the research that's out there, and then the plug for self-represented litigants. And Sean has a whole coaching thing on that, and he's the legal leg of the table too, because he's an attorney. David obviously is an attorney there in Canada. I saw a lot of comments complimenting you guys, saying they wish that you were here in America, specifically in New Jersey, from the one comment I saw fly by. But thanks again, and we will stay in touch and plan our next one. Okay.
It's a pleasure, like always, guys.
Thanks a lot, guys, for having us.
Okay. Take care. Bye.
Bye.
Bye.